Hey guys, hi everybody. I'm pretty surprised that there are so many people at 5 p.m. after 2 speeches on AI already. Hi Kuba. Just a few words about myself. My name is Michał Pękała. I'm a lawyer, video game lawyer, working with the industry for almost 10 years already. I'm helping developers, publishers, and all of the companies in the sector. Today I will be talking a little bit about AI. And just a caveat in the very beginning of my speech, this is going to be a very high-level overview of two issues that I pointed out and I think they often come up when I speak with developers, especially with developers. This is not exclusive, it's not everything that touches AI. It's impossible to talk about everything in 45 minutes, but I hope that these 2 points will raise some questions at the end of my talk. I'm happy to answer as many as I can. If I won't be able to answer them, feel free to reach out to me either during the party today or tomorrow. So let's go. The first thing to ask ourselves is basically, is there even a problem with AI in video games? Me standing here in front of mostly video game developers here, one may ask, so what's all this fuss about? The lawyer just shows up, we'll be talking about the AI. We are using AI in our studio. We are creating assets or other works with the use of AI. Everybody does that. What's the problem? All the lawyers in the world always create a problem. Well, at least some companies and accompanying lawyers that also advise them, they decided that there is actually a problem. And this is not a finite list of the cases that are currently being held by the courts, mostly in US, but this is just an example of 3 of those that are currently a very hot topic. 2 of them involve Stability AI, a very popular AI engine that the company called gAIns that did not think that it's that good as the Stability AI thought because of the way the Stability AI decided to teach its AI engine in a way to create pictures. So what Stability AI did was basically they invented their own version of scrapping engine that was running through the website, and all of the potential images all over the world, from all of the pictures, all of the websites, etc., and they counted 6 billion images that they were able to gather in order to teach their engine in order to produce the content that was eventually becoming the AI-generated content. A very similar case is being held against Stability AI with respect to the numerous number of artists that they feel that the way Stability AI was reproducing the images that they have been authors of was infringing on their rights. And the last one, it's programmers against GitHub, Microsoft, and OpenAI. This is actually a very interesting case because of earlier today, I just learned that the court in US decided to drop a few of the claims that was raised in the initial claim, but did not say that there is no claim at all. The court in US gave some time to the plaintiffs to come up with the better approach and the better understanding and resolution on the initial claims that has been put in the lawsuit. We will see how it goes. The main factor is that all of the defendants here are quite of the famous AI engines available online. So Stability AI is quite famous, it's recognizable. GitHub, come on, everybody knows GitHub. Microsoft with ChatGPT and OpenAI, this is a serious issue. Well, where will this lead with the eventual court ruling? We will have to see at least a year or more. But it gives us a question that if there is an issue, and what is the issue in the first place? And there are a lot of issues regarding the use of AI from the legal perspective. But the point blank, I will just say this right now. Do not be afraid of using AI. This is a way the technology will be emerging, it will be changing. It's like with almost any other examples of the technology in the past. There will be a people that will be afraid of using AI. There will be another group of people that will be very fond of using AI and will be engaging in it and will be advocating for the use of AI. This is not my point. I will not do that to frighten either of you or to discourage you from using AI. The only thing I can share my very limited knowledge on the AI so far is that You can use AI. Everybody can use AI. But you should do it with the better understanding of what are the limits of using AI, what are the challenges in using AI, and potentially what are the risks of using AI if you are using it without enough deliberation on the process. So, what is the problem? And there are actually two problems. I will start the first one. The first problem is the way how the AI engines are being taught, how to generate the content eventually. And in order to train to have the AI system in the first place, we need the raw data. This is like without the raw data, there will be no AI. There is no thing in the current state of technology that can create an AI that will be able to create or assist in creating anything without a huge portion data lakes of raw data. And in order to come up to this AI system, which you see at the bottom of the screen, the raw data needs to be put in the training data set. The training data set is basically some sort of, it's very simplified, some kind of algorithms which are designed to process the raw data in order to come up with another algorithm and enabling the AI to come up with the outcome. And in order to do so, based on the example with gAIms, there has to be a lot of data to enable your AI to be effective. The more you can come up with, the better the outcome of the AI creation will be in the past. So after we trained the initial AI system with the raw data that we included in the training data set, then it comes us. And then there is the first moment when we can interact with the AI that already learned itself to do something. And here, for instance, we can use commands, we can use prompts, we can tell the AI what we want from it. It can be a very simple question that you can ask ChatGPT. You can put prompt words in the chat box. For instance, create me a quest that will be involving pirate who is in a debt to a supervisor, etc., etc. There are a lot of ways. There are a lot of ways. You probably, most of you, if not all of you, had already encountered how the AI works in the real life, and you already saw the potential of using AI in the real life. So this is where we are. And we put the prompts or commands in the AI system, and then we have the output. This is the AI-generated output. This is the moment where gAIms got really frustrated and really angry with Stability AI. Because they saw that, okay, come on, what they did is basically they used our pictures that we put on the stock, and we gave license to use, even for the purposes of training databases for another AIs. But they didn't ask us. They did it. So this is the moment when some of the creators and some of the end users of the AI-generated content can potentially come into problem. And the last one is the refined output. This is like an extra. You don't have to do that. Some people do, some developers do, not just in video games. This is basically a moment where the output, the generated content that you receive from the AI, you further redefine it. You add something from your own. This is the moment where your creativity pops in, and you further change the output. It can be adding something to the picture that was created by the AI. It can be the change how the wording of the set quest about the pirate been created. You can rearrange whatever you want. This is what you got, and you can further change it. It also applies to music. It applies to the source code that is being produced with the Copilot, for instance. Whatever you can feel like, this is the moment where it steps in. And in most cases, in professional output of using AI, this is where it ends. Almost no one uses just the AI-generated assets as its own. In most cases, you have your own connection with the output, with the creation of the AI, and you add something else. Even not understanding that it helps you, but I will tell you in a bit why it helps you. So this is how it goes. This is what came out from the gAIms. And this is just one of the examples that gAIms got really, really frustrated, because they claimed, and at least at this moment, Stability AI has no good counter arguments, that Stability AI was saying like, oh, we only use your databases and your pictures to train our AI system. But gAIMS says, okay, but you, because of the, you says that it's only teaching itself, but the way we see it's almost the same picture. And this is where you don't agree. Ask me a question later. But from the perspective of how the copyright works and how many elements of the original picture has been used, it's really hard to come up with the counter argument from the Getty image that they used, from the Getty image itself, they used 12 million pictures to train the AI system. And how is it possible? What are the odds that just because the training, they come up with very similar picture? Of course, you can find differences, but the average spectator can easily connect two pictures together. The original is better. The face on the AI-generated picture is not that good. There is a watermark which is being trashed. Of course, that's all good, but still, there is a connection. There is a huge connection, and this is one of the problems that is being a base for the lawsuit. And also, it's important that from the standpoint from anybody who decides to use the AI, and it goes to the very essence of how the copyright law works. It doesn't matter if you knew or not. If you used a work that is being protected, you are being infringer. As simple as that. There is no goodwill here. There is no, your intentions are irrelevant. If you infringe on the rights of others, it's simple as that. It does not necessarily mean that the original author or the owner of the copyright will come up after you. It doesn't have to be like that. But it's really important to understand what can be the theoretical consequences of using the AI, especially the AI systems that are being produced and put over the databases that you do not know the source of. This is really important. And it leads us to yet another thing, that the EU authorities have recognized this issue a couple of years ago already. And in the directive from 2019, they allowed for this exemption, that they understood that because of the copyright law as it is, it's really hard to keep up with the changing pace of the technology. They decided that it's about time to introduce an exception allowing the companies throughout European Union to rely on that exemption and to use basically the DTM. Text and data mining. It's in US that would be data scrapping. It's the same. But it basically allows to reproduce the works that being in the databases for the purpose of teaching your own AI system. Just for this purpose under this example. And it's also important to say that from the perspective of the EU directive, this is not the law by itself. This is the direction for the EU member countries to then, based on that directive, introduce their own legislation in their own laws. And with respect to Poland, we are only 2 years behind the schedule. It's very good this time. There is, we usually 4 to 5 years behind the EU legislation, the moment where it's supposed to be enacted. This time is only 2 years so far. And this is the proposal. It's not yet the law that we can rely on. It's not in use anymore, but this is the latest proposal. It basically says that you can reproduce for the purpose of DTM, but there is also, as it was in the directive, as I shown a second ago, but there is one small and very important factor, unless otherwise restricted by the right holder. What does it mean? It basically means that for anyone who wants to use AI that will be teaching itself based on the publicly available databases, there has to be an opt-out system for the right owners of the right holders of the databases, of the works that are being held in the databases. In practice, it means that if I am the author of any picture, of any photo that is being published online or anywhere in the databases where you can find it, I need to be given a chance that I want to say, I don't agree for the AI systems to rely on my work in order to teach itself. It is difficult right now to predict what will be the practical outcome of this specific regulation. It can change. Please remember that this is not the final wording, especially that what it's not on the slide. It basically says that this opt-out system has to be embedded within the AI system itself. So it's not that I myself will have to say that I am opting out from this, but I will just give an information, and the AI system will have to be able to recognize by itself that that during the web scraping, for searching for the photos, let's say from the sports or any other kind of, it needs to be able to verify by itself that this particular photo uploaded by me or bought from me, or in any other connection. But regardless, when I said that I don't allow the AI systems to teach themselves with the use of my photo, that AI systems will need to be able to verify that. What will be the practical outcome? Hard to say. On one end, it's good that we are also introducing the legislation to the Polish copyright law to most extent in a similar way to how the most of the European countries are approaching this issue. On the other hand, as always, with any new laws introduced to the legislation, there will be some practical challenges, at least at first, how to understand, how to implement, and how to enforce that restrictions in future. But this is, in general, it's a good direction. Right now, you need consent to use databases which are not yours for the purpose of teaching your AI system. This will allow, to most extent, relying on the publicly available databases. So, we know that, at least for now, it's not that easy and it's not that simple to rely on the databases which are publicly known and available. So, but we still need to use AI. We want to use AI, it helps us, it saves a lot of money, it saves a lot of time. Everybody does it, the competition does it, we cannot be behind the state of technology, we need to use AI. What can we do about it to at least try and come up with the best possible scenario, enabling us to at least limit the risks, limit the challenges, and even to protect ourselves from the outcome of the works. These are, and I hate to say that, but this is to some extent a little bit ideal, because I am fully aware that if we use publicly available AI engines, which are being offered by the huge companies that provide AI systems, it will be really hard to rely on reps and warranties or the indemnification. For non-lawyers, it basically says that if you can, you should ask that the provider of the AI system tells you that I represent and warrant, which means I promise and guarantee that the AI system that you will be using and I have created was not taught with the use of database which can infringe on the right of third parties. Whenever you can, ask for that. Right now, most of the developers, most of the parties using AI which has not been developed by their own, it's basically most likely publicly available online tools. But this can change, and if this change, and it's really hard to predict the future, but it's not impossible for the providers of the current AI solutions to also come up with some more sophisticated versions of the AI, which will be paid or which will be more expensive than the basic ones. And if there's ever be a moment where there will be a chance for negotiating the contract with that kind of providers, you should at least try. I'm not saying that this will be easy. It probably will be very difficult, if not impossible, but still. If there's an opening, if you have a good catch on that, on the other party, try and use it. The same for indemnification. It basically says that if I am using your AI system and the third party that the work has been used for the purpose of teaching that AI come up to me and wants to sue me, or says to me that I have to take down my work because it infringes on his right, the provider of the AI that I paid or I used will step in my shoes and he will defend himself as he was me. And I will not be in trouble, at least in the legal trouble. Eventually, it will not stop that rightful owner from forbidding you from the use of the work created. But still, at least you will not be in the real trouble, legal trouble. You will not have to pay damages. That's still, it's better than nothing. It's not ideal, but it's better than nothing. The second point goes to the analysis. And with respect to the AI systems like Stability AI or Midjourney, it's of course not possible. But yet again, if you ever encounter, and it is possible in the next years that you will encounter AI providers that will rely, that at least in their opinion, on their own databases, or you created your own AI and you want to populate that AI with your own databases, you can think about trying to come up with some kind of internal analysis, due diligence, and try to find out as many red factors, red flags in terms of the works put in the databases as possible. Yet again, very ideal, very difficult. This is what we get right now. Or the third one, whatever you created with the use of the AI bases, or AI engines, treat as an inspiration, not as the final work or not as the final output before being refined. If whatever will be created as a result of you messing around with the AI, and you only treat it as an inspiration, let's say with respect to the image of the soccer players, but based on that photo, you will come up with your own picture. You will be in no trouble. Inspiration is fine. You can do that. I left fourth because this is just the start. The more we use AI, the more we learn about AI, the more cases we'll hear of and read about, the more ways to protect yourself will ultimately come up. I was struggling whether to put insurance here. I decided not to, because I really cannot predict when this happened. At some point, we can only predict that it will happen. When the AI strikes the ground and will be in general use by most of the developers working on the most of their games, it is only logical that also the other actors in the market will also like to participate in this field. And insurers are not different. And also, just to mention, last week's development of our EU bureaucrats, the European Commission proposed changes to the AI Act. It's and copyright in that respect, and they basically, without getting into the minutiae of the act itself, three important things. The first one is that this is going to be a regulation, not the directive, which means that whenever this is enacted, it is a law. It's like with GDPR. Whenever GDPR was enacted, there was no need to introduce anything. Well, to some extent. There was no need for the transposition of the directive to put to the Polish jurisdiction. This will be enforced by itself. But the changes that they proposed last week are interesting. Are interesting because I'll start with the C. It's easier one. So basically, the European Commission advised for introducing a requirement for the providers of the AI systems that they will be informing the users that, okay, if you want to use my AI system, I inform you that the databases I used includes the copyrightable works of third parties. I'm giving you a notice. And the other one is the B. And this B basically says that's to ensure adequate safeguards against the generation of content in breach of union law. This is very broad. It basically says that the AI systems that's supposed to be in general use or the services being provided with the AI should not be in breach of the union law. This is extremely broad spectrum. Our take on that is that it goes to the similar way of like the regulatory scheme as it was with the e-commerce, with the GDPR, and similar markets. It does not necessarily touch the copyright aspects. It can, potentially, but we don't go to that for interpretation as is right now. It's just the proposal. It's not yet, again, a law. You should observe. You should, when you can, learn about it, ask about it. When you have a chance to speak with a lawyer, it will take some time for this regulation to be finalized and be enacted. I do not expect to happen this in this year, to be honest. Maybe next. And another issue, another big issue. So we went through the aspects of teaching the AI systems with the databases and what are the implications, potential issues and challenges regarding that. But let's say you used it and it's fine. There is no issue. You check the databases or you created your own, you have your own AI, then you have the content that you were counting on. Because at the end of the day, this is why you use the AI. Not to play with data, but to have the AI-generated content. And there is a question: is it work, and who's the author, and what's the problem here? And a very brief, just walk through the very basics of the copyright law. It basically stands on three approaches. That any work is being created by human, intellectual effort. It has to be original or creative, and it must be expressed. I won't go into all of this, but the first one is important, and because it basically, at least from the perspective of the majority of the jurisprudence and practices and people that think about AI, it defeats the possibility of AI being able to produce a work that is being protectable because it's not human. This is not AI-generated content. This is a real case of macaque from a couple of years ago. There was a photographer walking around the jungle, and he encountered a macaque. Before that, he put his camera on stand, and then macaque created a great selfie, probably the famous selfie in the world. So why is that important in terms of AI? Because this guy was trying to claim the ownership of the photo that was taken by macaque. And after almost 2 years struggle with courts and trying to putting out a lot of good arguments, it's very interesting to read what the arguments he came up with. The court said ultimately that, well, you're not the author. So he asked, so who's the author, macaque? The court said, no, because macaque is not a human. So who's the author? There is no author. So in that case, when macaque took the big picture, that picture at the same moment immediately went through the public domain. Anyone can use it because there is no human link. And the same logic is being used with respect to the AI. But I wouldn't stand here if it was that simple. The next Rembrandt project was the project initialized by a group of very smart people that decided to use the AI in order to come up with almost identical approach to the way Rembrandt was portraying people. So what they did, they taught the AI engine with respect to all of the pictures of Rembrandt, not only Rembrandt. Before they populated the AI training scheme with the Rembrandt pictures, they first taught the AI system with all of the paintings that they could. Then they shifted to the Rembrandt itself, and they used very sophisticated way to use it. These were not prompts. They went way further than prompts. They were basically implying the AI system what they want to achieve. It's almost like if they have been communicating with the AI to the extent possible on the technological basis, as we've been talking to each other in terms of how the picture is being created. And this is the outcome. This is the outcome. That was created by the AI system with the very profound involvement of that group of people. And there is a lot of people, a lot of lawyers, me included, that can see and arguments that can be made in order to try and establish a link that this is just not an AI-generated content which is not protectable, but it went further, and it's shifting towards the AI-assisted content. If it was not challenged by court, so we cannot know for sure, but in jurisdictions like USA or UK, there is they are a little bit less restricted on that approach, and there is more possibility of claiming that if there is enough link that is being established between human and how the AI created, they leave away a very small opening indoor, saying that we are not saying that it's impossible. And it's very, very important distinction, which is also very typical for US courts, that the US judges always try to be at the same pace with the changing technology and the needs of the US market, and also they look how the rest of the world reacts. So I can only assume, and this is just my prediction, that there will be a moment where a judge, one bravely enough judge will say that I see a potential hint and I will grant the copyright protection, even before any legislation can come up. But there is another picture, and this is the picture created by me. I used the prompt at the bottom. This is what I used in Midjourney. Portrait of a man in a Rembrandt style. It took a few seconds. It's not protectable. The link here is way too weak. I didn't even a fracture of the effort that these people to the left did with this picture. I don't claim ownership to that picture. You can use it whatever you want, if you like. But what's important is that I'm not an expert in the field of arts at all. But one can say that it's not that worse from the left one, and that's the problem. That's the problem. This is the practical issue, because I can only imagine a situation where someone would use Midjourney or any other AI that will emerge in future, create a picture, and then try to make an argument and claim ownership of that picture, saying that, oh, I did the same what the guys from Next Rembrandt project did. And it's going to be in practice really, really difficult to challenge that. Because how can we challenge that? We don't have access to the database. We don't have access to the black box. No one can reverse engineer the way of thinking of the AI used to create that picture. How can we do that? So when I said that, I assume that there will be a court, a judge that will eventually come up with this idea of granting the ownership protection, which is to some extent, which is to a lot of extents good. It also creates an issue for potential overuse of the law by others that would like to follow and repeat that scheme. So if it's not copyrighted, then what? And what can we do about it? And I will this again. This is just this is a welcoming to discussing how can we protect the effects of the AI, the effects of the generated content that being produced with the AI, and the way that we want to use it in our games. Because when we, based on what we discussed so far, it basically says that this is like the basic argument. If you created something with the AI, you cannot protect that. So what does it mean for my game? I will include a picture or a character or the description of the weapons or the story or the quest in my game, and it's not protected. It creates an issue because it is everything that you have been told by lawyers over the years in terms of copyright protection and IP is that you need to have 100% of the IP to the game unless you will have problems. And now you start using AI, and the lawyer tells you that, oh, you will, right now, like from this moment forward, you will not have 100% of the IP to the game. So where that leaves us? It leaves us with a very peculiar position to some extent, because let's say you are being approached by an investor who is very interested in your company and your studio, and he really liked your game that you created a couple of years ago. Now you're working on a new title, needing $3 million to finish up the game. So what the investor does after you sign the LOI, he brings his lawyers. And these lawyers that have been doing that kind of transactions for years, they are not that smiley. They come up with shirt and ties. And what they want to do is due diligence. They will due diligence everything that you have on your records. And they will ask questions. And they will review the agreements with your employees. Everything is fine. They will use the license. They will review the licenses that you acquired. All good. And then there is an agreement, the investment agreement. And there is a very simple boilerplate reps and warranty, saying that I represent and warrant that I acquire all the IP rights to the game. And nobody ever negotiate that clause. Because everybody works on the assumption that you have all the IP rights to the game. Now, try to talk to that lawyers that have been doing this for 30 years and are not IP lawyers, that you don't have 100% IP rights to the game anymore, only 99. It's a red flag. It goes to the investor. They don't know what's happening, but there is a risk of losing money. Copyright infringement, a blocker. It already happened twice in my career, the last couple of months. We have been able to explain that the use of AI creates this issue. And it's impossible to overcome right now. It will need investors and all of the M&A lawyers to sit down with the IP lawyers and come up with some new solution to the approach of the reps and warranties. But this is just like one of the potential aspects, issues that can emerge. It's inevitable, at least for now, so this shall not discourage you from using the AI and AI-generated content, but it's good that you know that, but because it will happen eventually. So what can you do to protect yourself, to make this more as your own work? I will leave the first one as the latest one. I'll try to start with the trade secrets and NDAs. It is possible to rely on your trade secrets to the extent that you can generate an AI-generated content and you can create your assets and include it in the game and never tell anybody. And in most situations, nobody will know. Unless your worker, your employee, or your own just accidentally spill it outside. But you can rely to some extent on trade secrets. It's not the most legalish approach because it basically says that, well, you forget that you know something. I don't want to say you lie. But it is a way to go. I'm not recommending that. You can try. You can use NDAs to some extent to try and also enforce some kind of obligation on your own partners, employees, contractors, not to disclose that information. I can even assume or see potential NDA clauses in the agreements or EULAs with the AI engine providers saying that, well, we oblige ourselves not to ever tell anybody what you created. Clapping, yeah, good presentation over there. What you created with the use of my AI. I can see that. I'm not sure if it's going to happen that soon, but I can imagine that. I'm speculating. Contractual measures. To some extent, you can, and I already seen that a couple of times, that some of the AI providers saying that I grant you license or I transfer the ownership of the AI-generated content that you generated with the use of my AI onto you. Even though that the providers of the AI, they are in the full understanding of how the law works right now, but still, they anticipate the future, and they're saying that, okay, right now I'm telling you that this is licensed to you, or you get the ownership of that, even though it doesn't work. But if in 2 years there will be a pass of new legislation allowing you to acquire ownership or getting a license to the AI-generated content, we are assuming that you already have that license. And this is a very practical approach. This is the least the AI providers can do right now. But there is also a first one, which is basically, it's funny because this derives from the use of the shortcomings of the current stay of the copyright law to your own benefit, because it basically works like that. So you created this picture. I created this picture on the right. And this is the output that's being provided by AI. And then I changed it. I added some things to the picture. And the way how the current copyright law and the interpretation of the copyright law works is that I get the ownership in the elements that I created and added to the picture, not to the picture that is being created by AI. So how does it help me? If it's only to the extent with respect to these small elements being added to the picture. Well, no one knows what I added. It goes to the third, not telling everything / lying, but in practice it works like that nobody will know what I have added. So if there will be any third party trying to use an asset created by you and they have some glimpse of impression that it might be generated by AI, just add things. Because the way that almost all of the AI algorithms work is that they are non-deterministic. So the mathematical chance that the same AI using the same prompt will generate the same portrait is almost none. Plus, what are the odds and what are the chances that the same picture, by using the same prompts, which the third party doesn't know of, will be in the video game industry? I say next to zero. So only based on that approach, and to some extent this approach is put in the various guides that are being used right now by different developers. This is the fastest and the easiest and the most affordable way of using AI systems, which are publicly available, to your own benefit. Of course, it can be challenged in court. It is not safe to the extent that if someone will be able to show that, to prove that, well, you will lose. But it's not that easy. I say it's almost impossible. So this is the way how you can protect it. I was asked by my friend from WIPO, which is the World Intellectual Property Organization, to tell all of you that right now, any developer from Europe and from this region, can sign up for free IP advice on video games. To schedule a clinics, which takes 45 minutes, you can ask whatever questions you want on IP-related stuff regarding video games. It's for free, and it will last until, I think, July. And it's open for anybody. All you have to do is go to this website at the bottom and fill out the form. And maybe we'll meet there as well. If you have any questions, do we have time? 1 minute.
Yes, you mentioned that 99% of IP ownership might just get you in trouble, but what if you just use that texture from a website that has free for commercial usage images? Does that also make you in trouble for not having ownership of all the stuff in your game?
No, I said 1%, not 99%, can get into trouble if you use that with AI-generated content, but you're referring to the publicly available databases, let's say stocks with pictures.
Everything that's free for commercial usage.
Yeah. Well, the free for commercial usage basically means that's probably a CC0 license, which says that we allow you, the owners of this website, gather up all the, whatever you find on our website, for instance, in a simplified version, is that the authors of these pictures allowed for anyone else to use it. So you will not be the owner of that photo, but you will have a license.
And with AI, it's just risky because you might not be allowed to use them, right?
Well, you have to assume with AI that you do not have the license to use it, and does not necessarily mean that you cannot use it, but you don't have the legal title that can refrain others from using it.
Okay, thank you, Michał.
Thank you.